Hi there, can you hear me okay? Marie, type yes or give me a thumbs up. Let me know that you can hear me okay. This is my second only my second live ever. Thank you guys so much. Thank you everybody for popping in so quick. This is my second only live. The other one was last week in front of the Supreme Court. It only lasted a few minutes. Thank you, Marie. I'm going to be on the Veterans in Politics talk show tonight here in a little bit at 7 p.m. And so I just wanted to take this opportunity to do my live and see if anybody would pop in, and you have, so thank you very much for that. And I want to know if you guys have priorities that you want me to talk about tonight. I'll be on the show for about an hour. So if you have some priorities, start typing them in the comments so I can take a look at them and maybe ask you further questions, follow-up questions. In the meantime, I'm going to tell you a little bit about what's been going on. So for those of you who don't know, when you seek injunctive relief in the federal courts, you can ask for an immediate injunction. So that's you're welcome, Matthew. So that is a preliminary injunction. The way the escalation of priorities, this is how it goes. You have a TRO, which is a temporary restraining order. That's an emergency. You can look it up in the Federal Rules of Civil Procedure. I know you guys think I'm very good at this, but I don't have all these things memorized, so I can't tell you what rule to go look at, but go look at the rule on TROs. The federal judge can grant a TRO against somebody on an emergency basis. There's a time limit by which that has to be lifted to transition into what's called a preliminary injunction. And the preliminary injunction will basically be in place throughout the litigation as a stopgap measure to protect someone or their rights. Then you move on after the end of the litigation to the permanent injunction if you can prove up that you are entitled to that. And so I knew going into my federal litigation that a preliminary injunction was immediately appealable. That is an exception in the federal rules because most interlocutory orders, interlocutory means, during the litigation and not final. Most of those orders are not immediately appealable. You have to wait until the end of the litigation. And so in order to make sure that I got in front of the Ninth Circuit quickly, in case there were any shenanigans in the federal court, I immediately filed for a preliminary injunction asking the federal judge to enjoin Nevada Attorney General Aaron Ford, the District Attorney Steve Wolfson, and others from enforcing void ex parte fraudulent California family court orders. Now, the judge on his own, after taking, I forget, so that was in May of 2024 that I filed that. And he didn't make a ruling on that until November of 24, and he denied it. And he raised on his own a doctrine called the Rooker-Feldman doctrine. And what Rooker-Feldman basically says is that you cannot go to a federal district court to appeal a final state court judgment. It's a quirk in the United States Code. For those of you that don't know, 28 USC, 28 United States Code, that's the code that governs the courts. A lot of people think that the courts are just like this free-for-all that do whatever the heck that they want, and they certainly act like that a lot. But they're actually beholden to Congress on a lot of things. And just like on a random thought, so a lot of you know about the immunities and how I've been beating the immunities. Well, judicial immunity is something that the Supreme Court, it didn't create it, but it kept it alive from pre-America history. So it brought it into the civil rights realm and gave judges judicial immunity, like state judges. So you can't sue them for money under the federal civil rights law. But the Supreme Court has said over and over and over again that Congress, of course, could mandate otherwise and change that and remove judicial immunity. It's the same thing with prosecutorial immunity and qualified immunity. Most people, of course, follow this channel because of the Ninth Circuit cases that I'm posting and the obscene attempts by law enforcement to get immunity from their wrongdoing. But that, again, it is created by the courts, but they're still beholden to Congress. And anytime Congress wants, it could get rid of these things. I wish it had gotten rid of these things a long time ago, but they don't for a lot of crazy reasons, which we don't get into now. So 28 USC, so that's the part of the federal code that governs the courts. And in there, you'll find everything from jurisdiction and the stuff that I'm talking about preliminary injunctions. And of course, the federal rules of civil procedure are kind of like a parallel set of rules to the 28 United States Code. And so they both govern, and you kind of have to dance in between them. So somewhere in that 28 USC, and I don't remember the number, I'm sorry, is basically a mandate from Congress that says you cannot go to the federal courts to appeal a final state court judgment. The key word being final, right? And so unfortunately, and the reason for that is they want you to go through the chain of courts. So if you lose in your, like I'm here in Nevada, and I'm in Las Vegas, so we have the Clark County District Court. So if I have some kind of litigation in that court and I see it all the way through to final judgment and I lose and I'm unhappy with the result, then I go to the Nevada Appeals Court or the Supreme Court of Nevada. And then after that, you have to go straight to the United States Supreme Court. Those are your chain of courts after a final state court judgment. So Rooker-Feldman basically says, yeah, the law under 28 USC is you have to go through those chains of courts. So we can't come to federal district court to try to appeal something. The key word, as I mentioned, is final. So if you initiate federal litigation parallel to your state litigation, then you've already successfully gotten your way around Rooker-Feldman. Rooker-Feldman also, you can attack things, you're attacking things collaterally. So for example, let's say you were mistreated in the state court, but you're not trying to undo the judgment. You're just trying to, what's the word that they use in the case law? Ameliorate. It was hard to say, hopefully I said it well. If you're trying to ameliorate the effects of a bad state court judgment, you're allowed to do that in federal court. So if you bring a different cause of action in federal court against the person that mistreated you in state court, you're allowed to do that. That is not trying to undo a state court judgment. There are also several exceptions, one of which is extrinsic fraud, which is what is going on in my case, where people are going and having secret ex parte get-togethers with judges, and I'm given no notice and no opportunity to be heard, and they go and get these ridiculous orders or judgments against me. And so extrinsic fraud, you have extrinsic fraud and intrinsic fraud. So intrinsic fraud is something that happens within the case. And so that could be something like somebody filed or lied on the stand or something like that. But extrinsic fraud is something that prevents you from even getting a fair chance to litigate. Tell me more about it in the comments, Matthew. Also, I'm on here because I want to know, I'm going to be on the Veterans Talk Show tonight, so I want to know what you guys want me to focus on. I'm going to focus on the stuff that I've been winning on, which is pretty unique, and that's prosecutorial immunity and qualified immunity and how I even kept a judge in. So at any rate, there's several exceptions to Rooker-Feldman, and unfortunately the judge raised it on his own, got it totally wrong. The case that even cited himself in his order told him he was totally wrong, but he didn't read far enough apparently. He didn't read to page 6, he stopped at page 5. So given how flippant he was with it, even though I'm winning with this judge, I decided, okay, this is the chance, like let's escalate this because you know how it goes, right? You have judges misbehaving, you have lawyers misbehaving, you have cops misbehaving. So I was like, let's just get it in front of the Ninth Circuit. So I filed my appeal, I fully briefed it. The sole issue on appeal was Rooker-Feldman. And instead of addressing the sole issue on appeal, the Ninth Circuit just made something up out of thin air. And then I filed for a petition for rehearing en banc, and I pointed out to them that you just used the wrong legal standard, even though all parties agreed that you had to do what's called a de novo review, which means you start from the beginning. You don't give any deference to the lower judge. You start from the beginning, look at everything, and make sure the law was followed. Instead of doing that, they did what's called an abuse of discretion review, which is the wrong standard. Then they just made something up that the lower judge never even addressed. So then I filed the petition for rehearing, and not only did the original panel refuse to rehear it, but nobody on the whole court, which is like more than 20 judges, voted. They didn't even ask for a vote to go en banc. So we didn't even get an official vote, and so they just closed me out of the court. So what did I do? I put it right back in front of the lower judge. I filed a motion for reconsideration, and that's pending. And while that's been pending, there's been a ton of more misconduct mostly by Shelley Warnick's attorney, Mark Randazza. Shelley Warnick is my ex. Mark Randazza is her federal attorney. His partner is Ron Green. And so I filed a motion for reconsideration, which it's interesting because the reason I'm going to get away with that versus having to go straight to the Supreme Court next because the Ninth Circuit didn't do the right thing is right after the Ninth Circuit denied my preliminary injunction appeal, they came out with a case called Meroth versus Trinity County, and it's up on my channel. The oral arguments are up on my channel. And they basically said everything that I was arguing about in my appeal was correct. So they denied my appeal, and then like literally a week later came out with this ruling in this other case that's published that says that all my arguments were correct. So I put this before the Judge Gordon again, the lower court judge, on a motion for reconsideration. You can ask for reconsideration if there's new evidence, if there's new law, or if the judge made a clear error. So I pointed out all three of those things. Like number one, the new law was this Meroth case. The clear error was the fact that the case you yourself cited in your order denying my preliminary injunction on page 6 says that I'm right, and you clearly missed that. And then the new evidence, for most of you will know that he ruled in my favor on an anti-SLAPP reconsideration, and he used the summary judgment standard, which means he was looking at evidence, and he said, there's enough evidence here that a reasonable jury could conclude that Shelley Warnick and her family lawyer, Tristan Eshelman, defrauded the Santa Clara County Family Court in order to abduct my children from Nevada. So that he himself has found extrinsic fraud. And so that was his clear error. And also the new evidence. So now that that's pending, Mark Randazza, Shelley's attorney, is like filing all this frivolous crap. He missed the chance to actually oppose it. He filed an opposition because I asked the judge to reconsider all Rooker-Feldman orders, which means the ones on motion to dismiss, the ones on the preliminary injunction, and then there was also a separate summary judgment one. And nobody opposed, which was super interesting, except for Shelley. So the Clark County DA did not oppose the motion. The Nevada Attorney General didn't oppose the motion. The cops didn't. Nobody opposed the motion, only Shelley. And when she opposed it, she only opposed the injunction one, which she doesn't even have standing for that because the injunction's not going to be levied against her. That's another exception to Rooker-Feldman, by the way, is third-party restraint. I'm not asking the court to like restrain Shelley. I'm asking the court to restrain the government Grift Goblins. So third-party restraint is another exception to Rooker-Feldman. So she doesn't even have standing to oppose the preliminary injunction, but they filed this opposition to that. Because they didn't oppose the other stuff, that means that they waived it under the local rules. They consent to the granting. So long story long, sorry, but this is all important information for you. They're trying to claim that the Ninth Circuit already ruled against me, and it is ludicrous that I am asking this judge to reconsider something that the Ninth Circuit refused to give me. Well, as I've already mentioned, the Ninth Circuit didn't address the sole issue on appeal, which was Rooker-Feldman. The other thing is, if you look at their order, and I have posted this stuff, I'm doing the best that I can, by the way. I've been getting some complaints lately about not posting enough of the documents, but that's very overwhelming. And so let me pause here and mention one thing, which I'm going to mention tonight. I do use the Recap browser extension. So for those of you who don't know, Recap is Pacer spelled backwards. So Pacer is the federal court filing system. If you download this browser, which comes from a nonprofit, this browser extension called Recap, every time I pull a filing, which is every time something's filed, I pull the PDF and I put it on my local computer. Every time I do that, it's made public. So the PDF is made available to everybody. So most of my filings you can find very easily just by Googling. Look for a website called Pacer Monitor if you want to see the whole docket and whatever PDFs are available. So I'll look at your comments in a second, but how am I able to talk about this on YouTube without getting in trouble? It's not easy because YouTube's been throttling my channel a lot lately and it's very annoying. So at any rate, Shelley's lawyer is trying to defraud the federal court and say that they already ruled on Rooker-Feldman, and the Ninth Circuit's did not rule on that. And not only that, they said we're not even going to address his concerns about the orders on the motion to dismiss because they're not actually in this appeal. We can only look at the preliminary injunction. So this dude is just straight up defrauding this court as usual. He's been doing it for 2 years. I pointed out consistently, and the judges don't do anything about it. And it's not just this judge. I have another case in Las Vegas and I have another case in California, and they're not doing anything about professional misconduct. So I figured this was the time to file the writ petition, which you guys have seen on the post tab on my YouTube channel. And what I'm looking for there is for the judges to correct their legal errors, because there were several of them. I'm asking for them to start addressing the professional misconduct, and we'll see how it goes. You know, I have a very different view of the Ninth Circuit now that they've behaved the way that they did on the preliminary injunction appeal. But just like with YouTube, I knew going into this that the overlords were going to play games. So I'm ready for it, and I'm just going to keep my head down and keep putting in the work. And so if they don't do the right thing, then I'm going to make sure we publicize it, and I'm going to make sure that the House and Senate Judiciary Committees are aware of it. And I can't control them either, but hopefully at some point I'm going to create enough of a kerfuffle that somebody does the right thing. All right, let me pause real quick and take a look at some of these comments. This, be careful with Pacer. A certain amount of downloading is free, but then they will start to charge you. Be judicious in your downloads. Okay, that is partially true. So that the way the Pacer works is if you're in a case, if you're a litigant in a case, when something gets filed, you get served it by email. When you get served it by email, you get one free look. That's every document. You get one free look. And that's why I download it and file it immediately. So I have an Excel sheet where I've built a database of the filings that's searchable for me. And so as soon as something gets served on me by email, I enter it into the database and then I download the PDF. And I also move a copy of the email into that same folder for that date. So you get the one free look for every filing in your case. And so I've never spent money on Pacer. And I probably never will spend money on Pacer. The other thing about Pacer is there's a threshold. You have to cross, and I don't remember what it is, but you have to spend like $30 in a quarter or something like that before they'll even charge you. So if you spend $28, they just wipe it out. They don't even charge you for it. So, and then as I was mentioning with that recap, which is Pacer spelled backwards, none of you have to mess with Pacer because I'm automatically opening up the filings to the world. It does it automatically. So as soon as I download something, this Pacer extension sends it off to their database and it makes it totally public. So you should be able, again, go to Pacer Monitor is one of the websites that I know about. You'll be able to find most of the documents in addition to me posting the links that I choose to post on my social media. It says, I chose live on my YouTube channel. Are you the guy who has a crazy ex and is trying to hurt you by using your all's kids? Michelle, you'll have to be more specific because I'm sure there's a lot of people like that in this world. But I don't think, I will tell you guys this. I did speak to a reporter, and I'm not going to say who. I spoke to him several weeks ago, and he told me, the reason I spoke to him is because I went to the media headquarters and demanded it. And he came out and talked to me. And I thanked him for coming out and talk to me because it's impossible to get the media to come out to talk to me. And he told me, he's like, we get bombarded by angry fathers mostly, but angry parents. And, it's like, we don't have the bandwidth to figure out if that is even something that we want to report on. And then I went there with orders in hand to show him that I had beaten immunity for several of the government losers. And he's like, I have never seen a father take this to this level. So I will take pride in that comment from him. So Keith says, how are you able to talk about this on YouTube without getting in trouble? Well, okay, so and he's talking about getting in trouble from the family court. So an interesting side effect of what has happened with me is that since I filed these federal lawsuits, all the fraud in the family court has immediately stopped. So I don't have my children. I have not spoken to my children in 4 years or seen them and since they were seized and I was falsely arrested. So we haven't gotten there yet. But all these fake money judgments, because I have tons of money judgments like sanctions and child support and all this stuff that was all issued ex parte, without any due process, no cross-examination, no notice, no opportunity to be heard. So all that stuff ceased immediately. And there's now rumors, the judge's name is Judge Hendrickson in Santa Clara County, California. And why my case is in California and I'm in Las Vegas is a whole nother story, but that's more fraud. But apparently she's not even finishing her term and nobody knows why. She's exiting in January and nobody knows why. So maybe I had a role in that because I'm suing a bunch of judges, including the Chief Justice of the California Supreme Court. So we'll see. So why am I not getting in trouble? That's why. And by the way, that's a good point. And I'm going to talk about this tonight, Keith. You can sue a judge. You can sue a state court judge under the federal civil rights law, 42 USC 1983. Read that statute. Judges are a special group in that statute. What it says is you have to get declaratory relief first if it's available. And if a judge then continues to violate your rights and the declaration from the federal judge, then you can get an injunction and you can get the federal judge to enjoin the state judge. So that is how that is another mechanism. Now, the judges don't make it easy. And I have not had to push that particular situation because the family court judge is leaving me alone at this point. But that I'm gonna talk about that big time tonight, like as my priority. If you're getting your rights violated in a family court, you need to immediately sue in a federal court. Like, I don't know of any other way to protect yourself because everybody's in on it. The cops are in on it. The DAs are in on it, right? But if you sue that judge under 42 USC 1983, don't ask for money. You cannot sue a judge for money. They have judicial immunity. But you can get a declaration saying that what they're doing is violating your rights. Like if they're making orders without notice or opportunity to be heard, if they're not following court rules, if they're not allowing you to cross-examine witnesses, if they're not allowing you to call witnesses, right? And the earlier you do that, the better it is for you, because otherwise you're going to have to deal with a lot of these doctrines that have been made up over the years, like abstention doctrines, collateral estoppel, and a bunch of other stuff. So the earlier you can do it, the better. On your federal court's website is going to be a pro se handbook, and there's also usually a form that they want you to use to make it very easy, so you don't even have to type up a complaint. You can just fill out this form to file the lawsuit. All right, Good Luck says, I had no idea how dirty the court system was, especially family court, until I found your channel, Susan Bassey. I was so naive, I thought all the judges and the court system was fair. Yeah, I made that mistake for the first 2 years of my family law litigation. That's one of the reasons that this spiraled into what it's spiraled into. Keith, I was thrown in jail too. That's one of the things I'm suing. I don't know if you heard my remarks at the Supreme Court last week, but I talked about that. And I embarrassed the crap out of that judge that was involved in it. Matthew says, thank you for fighting. That's insane. Matthew says, I was never served. They held court so to out me and gave my ex-wife the house. That's extrinsic fraud. If you were never served, that's extrinsic fraud, and that's an exception to Rooker-Feldman in federal court. And don't forget, you have a 14th Amendment due process right that the states must abide by. Right? And so if you're not getting your due process, that's why you go into federal court. And you can attack orders as void. You can attack orders as void if there was extrinsic fraud, if you were not served. So that's under the 14th Amendment. It's under 42 USC 1983, and that's an exception to Rooker-Feldman. Also, most states, the Federal Rules of Civil Procedure mention void orders. I don't remember it. You'll have to look it up. But most states in their state civil procedure also talk about void orders. So look up your state law and look up the federal law for the circuit that you're in. I'm scrolling all the way up through the comments here, so bear with me. So I have followed your channel for some time. This is from Good Luck. It's absolutely heartbreaking, and you're sending me prayers. Thank you so much. All right, so I'm going to scroll back down, and bear with me again. I'm not good at this. This is my first live. Josie says, federal injunction as a sui juris is very difficult in Illinois district, in the federal court in Illinois, because they back all the family law decisions. Yeah, the federal judges don't make it easy, and it's sad. And that's another reason I just filed this writ petition. But one of the reasons I'm winning so much, and one of the reasons I'm comfortable and not like an emotional wreck, is because I've read all these cases. Like one of the things that I do that these stupid attorneys just like have not figured out yet, or I don't know what their problem is, but they file these frivolous motions to dismiss and all this other stuff, and they cite a bunch of cases, and I just read all the cases, and it never says what they claim, and it teaches me exactly how to, exactly what the law is and what my rights are and how to get around all that crap. So, but they just keep doing it. So, you have to read cases. I don't know another way to do it, but you have to read cases, and then you have to be willing to appeal and take it all the way. You can't quit. You can't quit because they're not going to make it easy. And that's another talking about I'm almost, by the way, guys, we're almost at 13,000 subs on this channel. And thank you very much for that. And thank you for all the support. That's why I started the channel while at the same time that I started my litigation, because I knew that they were going to mess with me. And so if they're going to mess with me, and if the Ninth Circuit's going to do something like use the wrong legal standard, despite all parties agreeing what the correct legal standard was, and then they're just going to make something up out of thin air, well, I'm going to make a very big public spectacle about that on my social media. And hopefully, at some point we force some huge change with the embarrassment or whatever it's going to be. I don't know. And maybe I get nowhere, but my kids are going to see this, and there's going to be a complete record, and they're going to know everything I went through and everything that I tried. So it's not easy, but I would recommend big time the social media to go parallel with what you're doing. So Michelle says, I could paint my husband 60 ways from Sunday from being a bad father. Doesn't discredit a billion times he has been a good father. Screw the courts. Nobody is perfect. Very good point, Michelle. I wish, for the longest time, my ex and I did basically behave that way. She, what happened is she filed this family law case surreptitiously in 2012 in Santa Clara. We mutually agreed to dismiss it. We both thought it was dismissed, and we parented from 2012 to 2018 without any court involvement. And then she got a DUI with the kids in the car in South Lake Tahoe. And we agreed at that time the kids would stay permanently with me in Las Vegas. She would do her rehab, and she would, handle her criminal case for that. And then she would move back to Las Vegas, and then we would return to a more equal co-parenting relationship. Instead, she got a plea deal, abducted the kids, and then started this roller coaster ride years running. So, Keith, I hear you. I know you're getting buried. Again, the only thing I can tell you, Keith, is social media and federal lawsuits. I don't know what else to do because everybody's in on it. This is public service. Ask me if I'm communicating with Susan Bassey. Susan has done several stories on me, so she's very familiar with me and my case, and it obviously goes into her realm too because my family law case is in Santa Clara County. I'm seeing a lot of stuff about John Mayer lyrics. Did you ever get a chance to depose Jeff Rosen? Okay, so that's a good question. So this is where we're at. My first federal lawsuit in Las Vegas stayed at my request while the Ninth Circuit appeal was going on. And then I just lost the Ninth Circuit appeal, right? So then I asked the federal judge to reconsider the Rooker-Feldman stuff because this is why it matters. He gave me a long time ago now the opportunity to amend my complaint, my lawsuit, which he has to do. That's another reason I don't want you guys to be afraid to go into federal court. It is the law of the land that they have to give you a chance to amend your complaint unless it would be futile to do so. So he dismissed some claims. Now, obviously, a lot of my stuff survived. That's how I beat Aaron Ford's qualified immunity. That's how I beat Steve Wilson's prosecutorial immunity. A lot of my stuff survived, but he did dismiss some claims on Rooker-Feldman. And so after the Ninth Circuit did its little circus thing, I went back to him with this motion for reconsideration. I said, look, you got it wrong. And if I'm going to amend my complaint efficiently, I need you to fix that so that I can amend my complaint efficiently. So the first case is stayed at my request until we get this all figured out, but it's going to discovery because I already beat all the motions to dismiss, or enough of them that I beat enough that we're going to discovery. When, I don't really know. I'm not in a hurry with this stuff because the main thing was to get back to my kids, which is what this preliminary injunction was about, right? That was part of it. And they've already taken 2 years screwing around with that. So I'm not in a hurry to to get through the litigation unless there's a mechanism there to see my kids. And I'm going to use the litigation and my First Amendment rights to torture the hell out of these government grift goblins. And eventually we will do the depositions. I'm going to have to fund all that myself. By the way, I have a buy me a coffee. I don't know if you guys noticed that. If you want to send any money to that, that would certainly be helpful, because I'm going to have to fund all these depositions and everything myself. And so Jeff Rosen is in the California lawsuit. Now, Jeff Rosen was initially in the Nevada lawsuit, but the judge dismissed him on lack of personal jurisdiction. And in some cases, the judge here was correct. In other cases, he was wrong. The pivotal question when it comes to personal jurisdiction is, did they direct activity at Nevada? If they directed activity at Nevada and caused harm in Nevada, the federal court here can exercise personal jurisdiction. If not, then not. And so the judge's perspective here was that Jeff Rosen did not direct any activity at Nevada, which is maybe technically true, because what happened was he conspired with Vern Pearson, who's the district attorney from El Dorado County, who did direct activity at Nevada. And one of the things that I learned in my litigation is you can't put the cart before the horse. You can't allege conspiracy to get personal jurisdiction. You have to prove conspiracy to get personal jurisdiction. So a lot of the motions to dismiss, some of them were on one point maybe legit, and so I just conceded, and I told the judge in my responses, I concede, you can go ahead and dismiss this portion because I don't want to waste judicial resources. So Jeff Rosen got dismissed from Nevada. So then I filed the case in California. That one is against judges. It's against California bar dirtbags who refused to investigate Tristan Eshelman's fraud on the courts and all these other fraudsters. And it's against it's against Jeff Rosen and his team, the state bar. It's against a bunch of judges, including the Chief Justice of the Supreme Court. It's against the Santa Clara County Bar Association. It's also against Santa Clara County and the city of San Jose for protecting all these people. That's a Monell claim. We can talk about that later if you want, because I don't want this to go on too long. I got to get ready for that show. So at any rate, that judge has been feeding these orders on the motions to dismiss slowly over 8 months. So that's another reason I filed this writ petition with the Ninth Circuit, because these orders are never coming. So, Jeff Rosen's time will come, I promise you. But we have to get past the motions to dismiss before we can start discovery. All right. Okay, I think confused. Josie says, I'm confused about you citing Rooker-Feldman. They use Rooker-Feldman to kick family court cases from federal court. You don't take a family court case to federal court. I will say this, I need to go do some research, because a California federal judge just came out with a way to get around, and I did do a social media post on this, and I posted his order, but he talked about how to get around the domestic relations exception. But I haven't had time to look into that, and so I can't speak intelligently on it right now. But you don't take a family court case to federal court. You file a civil rights action against the losers who are depriving you of rights. And I do want to say this before I forget. I'm going to mention this tonight. A judge has judicial immunity from monetary damages, but a private party who conspires with a judge to deprive you of rights does not enjoy that immunity. So that's one reason that my case is proceeding against lawyer dirtbags, and I would highly encourage you all to look into that. And I don't know if I have, let me see if I can bring up the case citation quickly for you. One of the things that I do is I have a master arguments word processing document. And as I read cases, I take those important holdings and I put them in that document under headings like pleading standards, or notice and opportunity to be heard, or leave to amend, or judicial notice. And so that way I never have to go back and find those things again. They're all right there and they're searchable. So let me see if I can find this for you quickly. Should be under conspiracy. Yeah, here we go. Private parties who corruptly conspire with a judge performing judicial acts violative of constitutional rights are acting under color of state law, which means that they can be sued under the civil rights statute, because anybody who acts under color of state law can be liable for a constitutional rights violation. So let me read that one more time. Private parties who corruptly conspire with a judge performing judicial acts violative of constitutional rights are acting under color of state law. That's Dennis v. Sparks. It's a Supreme Court case from 1980, and the citation is 449 U.S. 24. All right. Hey, Susan Bassey. Yeah, Hayashi's a nightmare. I wish Hendrickson's going, I heard, but what about Hayashi? We got to take care of her. And I'm going to take care of her in our video deposition. Let's see what else Susan has to say. Susan, by the way, everybody in here was asking me if I had talked to you. And I've said that you've done several stories on me because my case extends into your domain because my family court case is in Santa Clara. So yeah, Susan says that Hayashi's orders and court files are horrific, and the things we have seen have resulted in mind-bending harm to families and children. For sure. For those of you who don't know, up on my channel, you can see Hayashi be a total dirtbag because we have cameras in our court in Nevada. And so the hearing where the Nevada judge ceded jurisdiction to Santa Clara for no reason, based on ex parte fraud, Hayashi was involved in that. And she's you can hear her in the video over the phone. And you can hear her admit to reading ex parte declarations. So I encourage you to go check that out. Josie says, pose a federal question. That's absolutely right. That's a good point too, by the way, Josie. If you get federal question jurisdiction, now remember I told you 28 United States Code, that's the statutes that govern the federal courts. In there you will find the things on jurisdiction, how a federal court gets jurisdiction. Federal question jurisdiction is one of them. A civil rights violation is a federal question. Once the court has federal question jurisdiction, it can exercise supplemental jurisdiction, which means you can bring state law claims in there too. So I haven't talked about this a lot on my social media, but a lot of my claims are under the Nevada Constitution or Nevada law, like abusive process. And so that the court can adjudicate those under its supplemental jurisdiction. And that brings up another important point, which I'm going to talk about tonight. Under the Nevada Rules of Appellate Procedure, a federal judge, so this is the Nevada rules are for the state appellate courts, right, and the state Supreme Court. Under those rules, a federal judge can pose a question to the Nevada Supreme Court. And so I asked my federal judge to do that. I asked him to pose the question to the Nevada Supreme Court, does tortious interference with parental rights exist as a cause of action in Nevada? And he has agreed to pose that question. So as we start getting this case a little further down the road, he said, file the motion and I'll send it. So he's going to send it to the Nevada Supreme Court, and we're going to see what they do with that. But maybe we get some new law in Nevada. Okay, I didn't know how long I was going to be on here today. You guys, thank you so much for showing up. Josie, the interview is going to be live on Facebook. I posted the link on my post tab on YouTube. And so let me I'll give you guys a few more minutes. Are there any questions that you want me to focus on tonight during the talk show? Anything at all? So I mainly want to talk about how you can sue a judge immediately in federal court for declaratory relief. I want to talk about how I beat prosecutorial and qualified immunity. Of course, I'm going to go into the history of my case and how all this happened. But do you guys have anything that you want me to focus on tonight? I'm going to take a drink here real quick because I've been talking for a while. So I'm going to see if any comments pop up. If I don't see any, I'm going to get off here in a minute or two. All right, I'm not seeing any come up. So let me just, I will try. Let me, you know what? I'll mess with that. I'll try posting the link once I get off the live and see if I can put it in that way. Because I'm one of my frustrations is my technology. It's never working right. I have all the Apple products, and for some reason they're just not working, which is why I'm using my phone on my desk right now instead of a more professional setup. So I'm hesitant to try to go and copy and paste the link into the live right now. Yes, I'm on Facebook. So I have my personal channel, which is Michael Sternberg, and I don't accept friends requests from people I don't know and haven't met personally, but I do make a lot of public posts about what's going on, including my filings. But yes, also I have the business page at Father in Exile on Facebook. You can come find me on LinkedIn too. I'm terrorizing the hell out of the lawyers and the government grift goblins on LinkedIn. We got your like personal friends, Josie, or Father in Exile friends, like you're following Father in Exile. What else was I going to say? So LinkedIn, X. Now on X, it's interesting. I'll have to go back and look at it and see your face, Josie. On X, it's at Father_in_exile. And what else? I have the Substack. If you guys are not on my Substack, yeah, LinkedIn is freaking. It's so fun. The number of lawyers and judges that are freaking out and looking at my profile, like thousands of views of my profile from lawyers, because I'm over there all the time, just talking crap, because they put these glowing posts about themselves and the good fight that they're fighting and all that stuff, and I just terrorize them. So LinkedIn is a lot of fun. You can follow me there. Where was it? Oh, Substack. So Substack is, I've got 3 articles up. Now, Substack I've found to be the best place where I can link to documents. So when I type up a good article like how I beat prosecutorial immunities up there, I link to all the evidence so you guys could see it. Could you ever think of a reason that you could file in Nevada federal because the proceedings in California are causing physical assaults? You have to have a federal question to get into federal court. That's not the only way to get into federal court, but that's the chief way that I do it. The federal question means your federal constitutional rights are being violated. So you have to find the hook. And again, I don't want you guys to ever be afraid to go in there. There's always a way to do something. You just have to figure it out, which requires studying and learning, right? So you have to figure out, how are my federal rights being violated? That gets you into federal court. And then you have the personal jurisdiction issue. So I'm in Nevada, and Jeff Rosen technically did not direct any activity by himself without alleging conspiracy. He did not direct activity at Nevada. So he probably rightfully got out of the Nevada lawsuit. But El Dorado County District Attorney Vern Pearson and his goons, they directed activity at Nevada. They went and lied to an El Dorado judge to get a warrant for my arrest. They did not disclose to that judge all of my communications with them for the prior 2 years and all the exculpatory evidence. They got that warrant. They then gave it to the imbeciles at the Nevada Attorney General's office, along with my description and address and all that stuff, and caused them to arrest me. That's directing activity at Nevada. So this court can and should, and I hope the Ninth Circuit will order it to, exercise personal jurisdiction over Vern Pearson and the rest of the losers at the El Dorado County District Attorney's office. But I couldn't plausibly come up with an argument for that to work for Jeff Rosen. So you're gonna, your facts. I've given you a skeleton framework of the law, so you're just gonna have to go and look that stuff up. I just said the word plausibly, so I want to leave with this because I didn't get any more questions. The pleading standards. Let me see what I got on my master sheet here. Okay, I'm gonna leave you with these holdings that I have on my master arguments word processing document. This is under my heading for pleading standards. Pleading means you're filing your lawsuit, your complaint, right? And it's not hard to do that. The federal rules require a plain, short statement of a wrong. So, thank you, No Name Joe Blow. I appreciate that. So. Of course, your opposition will then file frivolous motions to dismiss to try to kick your complaint out. And, sometimes you get a crappy judge that'll go along with it. But you just need a short, plain statement. That's what the Federal Rules of Civil Procedure say. And here are some holdings that you can look into. Now, remember, this is all Ninth Circuit stuff that I'm citing. So the Supreme Court of the United States governs everybody, right? If you start citing appellate cases, you want to try to find appellate cases that are in your appellate circuit. We have 13 appellate circuits. You need to find something similar in your circuit. So here are some holdings. Also, because of the due process violations alleged throughout my first amended complaint to include the withholding of my family court file, relevant facts are known only to the defendants and the court should relax the pleading requirements. So the key part there was relevant facts are known only to the defendants and the court should relax the pleading requirements. So that was Sue Park v. Thompson. That's spelled S-O-O, Park v. Thompson. That's 851 F3D 910. My allegations must contain sufficient facts to give fair notice to the defendants, and those facts taken as true must plausibly suggest an entitlement to relief. That's AEX Hernandez v. County of Tulare. That's 666 F3D 631. And further, the Supreme Court has instructed the federal courts to liberally construe the, quote, inartful pleading, close quote, of pro se litigants. So that's Eldridge v. Block. That's 832 F2D 1132. So I want you guys to know there's tons of case law that's on our side. You just have to learn it and find it and put it to your facts and to your situation, and you have to work the process. And again, I'll leave you with this. If you go to your federal court's website, they will have a pro se handbook that teaches you how to handle yourself with the basics in federal court. They will have forms you can use, including a civil rights lawsuit form, so you don't even have to type up like a legitimate complaint like a lawyer would. So go check out those things, and remember, you can sue a state judge for civil rights violation. You can't get money. You have to get declaratory relief first. That's in 42 USC 1983. That's a federal statute. You have to get declaratory relief first if it's available. If that state court judge or family judge continues to violate your federal constitutional rights, you can then get an injunction from the federal judge. So I'm going to end it there because I've been on for a long time and I got to get ready to be on the Veterans in Politics talk show tonight. Thank you all so much for joining me. I hope you learned something from this. Please see us tonight on that show. It's going to be live on Facebook. I will try to post the link in here once I get off, but otherwise it's on my post tab. So just go to my channel, go to my post tab. It's there. For those of you that were asking about my other social media, I already posted it all there too. So it's on my LinkedIn, on my Facebook, on my X. Marie, thank you so much, and thank you for your loyal support. I'm glad you can see me talk to you live because you have been there for a long time, and it is very, very much appreciated. So thank you, everybody. I'm going to go give Guava and Georgie some love and get ready for the show. I'll see you tonight. Have a good night, everybody.